Hello, my name is Dr. Ed Sutherland and I'm a lecturer in the Institute of Psychological Sciences here at the University of Leeds. Although my main research interests are in reasoning and decision making and the psychology of design, I want to talk to you today about an altogether different topic: false confessions to crimes. There are a number of important aspects to this topic and we will look at each of them in turn. Over the course of this podcast, I want to cover the following topics: the importance of confessions in the legal system, the implications of making a false confession, interrogation techniques used by the police to elicit confessions, different types of false confessions, and experimental recreations of false confessions in the psychology laboratory. Another podcast in this series has covered the nature of eyewitness testimony, that is, the evidence given by a witness to some crime or other. If you have already seen this podcast, then you will have some important knowledge about eyewitness testimony. But let me summarise some of the important aspects for you here. The identification of a suspect by a witness is compelling evidence for a jury and typically has a powerful effect on their verdict, and is sometimes the only evidence used to ensure a conviction. Wells and Olson, 2003. Despite the fact that it has been frequently and repeatedly demonstrated by psychological research that eyewitness testimony is fallible and error-prone, such as the extensive work of Elizabeth Loftus, who has shown that eyewitness testimony is open to numerous errors. In a similar way, a confession by a suspect is also seen as a very powerful piece of evidence by a jury. If someone confesses to a crime, then they must surely be guilty, is the assumption that is usually made. It is an admission of guilt and is rarely questioned. While it is the case that the majority of confessions are likely to be true, there is some evidence to suggest that false confessions are made, where people who have not committed a crime have nonetheless admitted their guilt. While it's hard to know exactly how many confessions are false, some are discovered quite early in the process, others later on when new evidence comes to light, and there is of course the possibility that there are some false confessions that are never uncovered, there has been some research to try to discover how prevalent the issue of false confession is. For example, Gudjonsson and Sigurdsson in 1994 interviewed prison inmates and found that around 12% of them claimed to have made a false confession at some point in their criminal careers. A well-documented case of false confession in the UK is the case that became known as the Birmingham Six. These 6 men had been accused of involvement in an IRA bombing campaign in 2 pubs in Birmingham in 1974, which had resulted in the death of 21 people and many more being injured. However, the point of interest for us is that 4 of these 6 men confessed to the crime despite knowing that they were innocent. While it's not my intention to look at the specific confessions in relation to this case, it does raise the important issue of how central a confession can be in securing a conviction. Although there was evidence of some police mistreatment and flawed forensic evidence, the most compelling evidence was the confessions that had been given to the police by these men. The 6 men eventually had their convictions quashed by the Court of Appeal in 1991, but by this time they had already spent over 16 years in jail. This case shows that false confessions can have significant implications for both the individuals accused and also for the state, in terms of the sense of trust in the justice system and the financial implications, the cost of imprisonment and any subsequent compensation that may need to be paid. You can also find material on the importance of false confessions by looking at the US public policy organisation, the Innocence Project. The Innocence Project aims to achieve release for prisoners wrongly convicted and typically has used DNA evidence to prove the innocence of many prisoners. The project also campaigns for important changes to the US legal system to reduce the levels of false imprisonment. The statistics currently available from the Innocence Project suggest that in 266 cases where DNA has proved prisoners to be innocent, around 20 to 25% of these convictions involved a false confession being given to the police at some stage. As we saw earlier, there are dramatic and serious implications of false confessions, and none more so than in the US, where the average sentence served by these innocent individuals was 13 years, and 17 of them had spent time on death row awaiting execution. Leo and Ofshe in 1998 also noted that there have been executions conducted on the basis of false confession evidence. As a result of the importance and prevalence of false confessions, there has been an increasing amount of work in psychology to try to understand the process of eliciting confessions and why false confessions might be made, and to consider the implications of this research for the legal system. It is essential to note that the techniques that are used by police when interviewing suspects and attempting to secure a confession can vary from one country to another, depending on the law of that country. For example, here in the UK, police interviews must be recorded, but this is not the case everywhere. There are examples of police manuals that outline the best ways to secure a confession from a suspect. For example, in the US, the manual produced by Inbow, Reed, Buckley and Jane in 2001, and these typically outline several strategies or techniques that may encourage confessions. There has been a lot of documented work in psychology that shows that participants are vulnerable in the presence of authority figures, such as the work of Milgram in 1974 and Zimbardo in 1982. Within the legal system, along with the presence of authority figures, suspects may find themselves socially isolated for long periods of time in police cells, and this can lead to them becoming frightened and stressed. This can be coupled with techniques such as acting in an intimidating manner and stressing the seriousness of the crime and the situation, and perhaps also about the nature of the evidence that exists against the suspect. This technique is known as maximization, as it serves to maximize the seriousness and consequences of a crime. An alternative approach is that of minimization. This is where the police interviewer acts in a sympathetic manner towards the suspect, suggesting that the crime was in some way perhaps understandable and potentially the fault of the victim. Both of these techniques are likely to result in a confession being made. Indeed, Gudjonsson has stated that somewhere between 40 and 70% of all police interviews result in a confession. Rossano et al. 2005 found that minimization techniques coupled with the explicit offer of leniency towards the suspect was likely to result in a confession. While confessions were more likely to come from guilty suspects, they reported that minimization and the offer of some form of deal for cooperation was also likely to yield false confessions. Consequently, they argued that techniques that suggested leniency coupled with minimization should be avoided, as these were most likely to lead to false confessions, and one would consequently have to question the reliability of any confession that had been secured in this way. Another approach that may be used by the police, although not legal in the UK, is to suggest that there exists some compelling evidence against the suspect, which may be that there is some forensic evidence against them, or that an accomplice has already confessed and implicated the suspect. This too is likely to encourage a confession. In the light of such compelling evidence, it may be better to confess, as there appears to be no way out of the situation.